Think about this for a second. How can you claim an entire continent with just a piece of paper? It sounds impossible, right? Well, today we're going deep on one of the most powerful and, frankly, controversial legal ideas in all of history, the doctrine of discovery. Let's get into how this all started. What you're looking at here is really a story of two worlds meeting, and each had a completely different idea about law, about land, and about how to live together. On one side, you have the canoe, symbolizing an indigenous vision of peaceful coexistence. And on the other, you have the ship, representing a claim of a divine right to conquer. You know, long before those ships ever showed up, there were already these incredibly sophisticated legal frameworks for diplomacy here on Turtle Island, which is the name many indigenous peoples use for North America. We're going to start with one of the most important ones, the vision of the Haudenosaunee Confederacy. And that vision? It's literally woven into this, the two-row wampum belt. Now, this is not just some historical artifact. It's a living, legal document. See those two purple lines? They represent two vessels, a Haudenosaunee canoe and a Dutch ship, traveling together down the river of life. Each boat has its own laws, its own culture, its own people, moving in parallel, but never ever interfering with the other.
This right here, this is the heart of the agreement. It's all about mutual respect and autonomy. It's an agreement between equals. And did you catch that last word, forever? This wasn't supposed to be some temporary deal. It was meant to be a lasting relationship. But the people who came on those ships, they brought a very, very different worldview. A worldview that wasn't about sharing the river at all. It was about owning it. And this idea was made official and given religious authority by something we now call the doctrine of discovery.
So this guy right here, this is Pope Alexander VI. Back in the late 1400s, the Vatican started issuing these decrees, they called them papal bulls, that basically gave Christian explorers a divine green light. It was the church giving its blessing to European kings to go out and seize lands and peoples.
So what did this doctrine actually do? Well, at its core, it said that if a land wasn't ruled by a Christian leader, it was considered terra nullius, nobody's land. Just think about that. It was a powerful legal trick that dehumanized indigenous peoples, essentially erasing their entire societies and their rights from the perspective of the colonizers.
And believe me, they were not subtle about it. The language from the papal bull Inter Caera is just shockingly direct. The Pope, claiming authority from God, is literally giving the kings of Spain the right to own lands they haven't even found yet. I mean, the sheer audacity of that assertion of power is breathtaking.
Now, you might be thinking, okay, this is just ancient history, right? A religious thing from 500 years ago. But here's the kicker. This doctrine didn't just stay in the Vatican archives. It jumped directly into the legal systems of the United States and Canada, and it became the actual bedrock of modern property law.
Let's just trace this legal inheritance, okay? It's a direct line. In 1823, a U.S. Supreme Court case called Johnson v. Minchetosh explicitly pulls the doctrine into U.S. law. It argued that European nations got absolute title to the land simply by discovering it. But look at that last date, 2005. This is not a historical relic.
That's right. In a 2005 Supreme Court decision, written by none other than Justice Ruth Bader Ginsburg, the doctrine's modern power is confirmed. The ruling basically says that the legal foundation for land ownership in the United States still rests on this 15th century idea of discovery.
And that brings us right to the heart of the conflict playing out in courtrooms today. We have two fundamentally different, totally competing claims to the exact same land, and they both stem from these two clashing worldviews we've been talking about.
Okay, let's break this down. On one side, you have Aboriginal title. This is an inherent collective right based on the simple fact that indigenous peoples lived on and governed these lands for millennia before any Europeans showed up. And on the other side, you have fee simple title. That's what most of us think of as private property, something you can buy and sell granted by the state. The huge problem is that colonial governments just started handing out these individual titles as if Aboriginal title didn't even exist.
So this is the simple, profound question at the center of all the modern land rights battles. How can you give away something that you don't actually own? It's a basic principle of property law, and it's the elephant in the room that governments have been trying to ignore for centuries. And now, courts are finally being forced to deal with this head-on. Take the recent Cowichan Tribes case. The court ruled that just handing out private property deeds to settlers did not automatically erase the pre-existing Aboriginal title. This, as you can imagine, creates massive legal uncertainty. It raises the huge question of how to reconcile these two overlapping rights on the same piece of land today.
So in response to this whole legacy, Indigenous peoples are now using new tools, both here at home and on the international stage, to push back, to reassert their rights, and to challenge the very foundation of colonial law.
One of the most important tools is UNDRIP. That's the United Nations Declaration on the Rights of Indigenous Peoples. The UN adopted it back in 2007, and it lays out the basic human rights for Indigenous peoples around the world, including rights to their culture, to self-determination, and to their lands.
And a huge principle in the Declaration is something called free, prior, and informed consent. This isn't just about, a government holding a town hall meeting. It's about genuine cooperation and getting consent before big decisions are made. It's a fundamental power shift away from that old top-down colonial style and towards a relationship of equals, which, if you think about it, sounds a lot like the original spirit of the two-row wampum.
But this story is far from over. Actually, just very recently, one of the most significant events in this whole 500-year history went down, and it brings us right back to where it all began.
That's right. After decades of relentless advocacy from Indigenous leaders around the world, the Vatican officially disavowed the doctrine of discovery. The very institution that wrote the original papal bulls declared them illegitimate.
And in their own words, they admitted that the decrees were manipulated for political purposes. The Vatican acknowledged that these documents, which were used to justify centuries of violence and dispossession, completely failed to recognize the basic human rights and dignity of Indigenous peoples.
And this leaves all of us with a really profound and unsettling question for the future. The religious and moral justification for colonial property law has just been rejected by its own author. So, what does that mean for the legal systems, the property lines, and the very nations that were built on top of that foundation? That is the unfinished business we all face today.